13th, 2016, and it is 6 p.m. We have before us an agenda for this evening. If we could call to order, the meeting's been called to order, and if we could have a roll call of attendance.
Okay, Mr. Cowling?
Here.
Mr. Steele?
Here.
Mr. Field?
Here.
And for staff, Mr. Colhay?
Here.
Mr. Gisler?
Here.
Ms. Stuller? Here. Mr. Severin?
Here.
Everyone is present.
Thank you. The next item we have is a new business item, and it's the hearing of case BCA 04-2016, appeal of the building official's letter on finished basement valuation and fees. Maybe I should make sure that we didn't want to have any change to the agenda. Is everyone comfortable with it? So with that said, we have before us the appeal, and might be good just to make sure everyone has all the information that's been distributed. When you came, I think there was a packet of everything that had been distributed to date. Has everyone on the appellant side and municipality side have all the information?
I don't know if anything else was handed out today.
There was.
I added the scope letter that we sent on May 25th, that we sent to you.
May 25th letter, yeah.
And you should have gotten the letter from Lisa as well.
A letter or just the email yesterday?
Just the email.
Well, it was the email, but it
with an attached document.
had an attached document.
I don't think I saw it.
It should be right behind you.
So I think at this point, anyone that's going to offer testimony or comment this evening, we need to have you swear in, and I can go ahead and read the question posed to all, and anyone that, of course, will be offering anything needs to affirm. Do you affirm under penalty of perjury that the testimony you are about to give in this matter before us is the truth?
Yes, I do.
Thank you. So procedurally, what we do at this point is we have an introduction of the case by the city. Following that, if there are any specific questions, we can field those from the panel. And then following that, we would have the appellant's statement or restatement of the appeal, and again followed up with questions. Once we've gone through that procedure, once we've heard both sides, I think the point is that we should make sure that we don't go on at length with discussion without formalizing a motion, and then go into a discussion mode so we kind of keep it focused and we have something before us. I think that might be a better way to find our way through this if everyone's comfortable with that.
Yes.
So with that, would like the city to go ahead and make their presentation.
Just the brief introduction, correct?
Pardon?
The introduction, correct?
Yeah.
And then
Yeah, I'm sorry.
so thank you. We're appearing here to defend the decision by the building official regarding the appeal by Mr. Thompson for refund of fees that are based on the valuation of finished basements. We provided some information I believe everybody has. We provided, first of all, the legal brief from the municipal attorney's office that objects to the authority of the board to decide this case. And we also provided the May 25th denial letter from the building official to Mr. Thompson. And we apologize for not getting that to everybody earlier. It was my fault. I left it out of our staff packet that we prepared and submitted last week, so my apologies for that. And then we have the staff packet I just referred to, which just expands on the arguments presented in that letter. said a minute ago, we don't, our position is that the board doesn't have the authority to decide on financial matters that would result in the requirement of the municipality to pay monies. That was discussed in the brief that the municipal attorney's office prepared. So at this point, we would request that the board decline to hear the case based on that.
Okay. Any further presentation? Hearing none, any questions?
Yeah, I have a question. When I read through our manual that we were given when we got on the Board of Building Regulation Examiners and Appeal, in 3 areas, and in particularly since this is a 3-member panel, I'm going to read under this. It says this is
Can I
under...
get you to give the
Yes.
citation on the section?
The citation is 23.10.103.4.3C. So this doesn't speak directly to the authority as to decide whether monies should be given or not given and exactly what authority we have, but I believe that this states that we do have the authority to hear this case. It specifically says the 3-member hearing panel, a building board 3-member hearing panel shall hear and decide appeals from decisions of administrative officials and other enforcement orders relating to code regulations under Title 23. And I believe that you're stating that these fees are under Title 23. Is that correct?
They are. They're addressed elsewhere in code as well, but they are.
So, in my opinion, that tells me, at least in my opinion, that tells me that I think that we are or could or should hear this case.
Okay. Any follow-up to the statement or question?
Sure. I guess I want to clarify one thing. I made a similar objection the last time we were here, and I sort of restyled it a little bit because I realized I don't want to come in and have sort of the loudest voice in the room and go first and be sort of obstructionist. So I want to clarify. I think hearing it versus ultimately issuing an order to the municipality to write a check are sort of different. I think there's lots of benefit to being a public process and allowing you to hear it, and if something's not going right, to make comment or something on it. I just, as I laid out in what I wrote, I don't believe the building board has that ability to say municipality write a check. I think that's a really unique thing. Now, as far as hear it, have some public process and do something. So I think Kent, and he might have just phrased that wrong, because I think hear it is a different story, Brad. But it's just that if we get an order from the building board that says, cut Thompson a check for $5,000, just in the way the rest of the code is and everything, it just is a tough sell to me to say that we have to, I guess, honor that. I don't want to be disrespectful, but that's the part where I don't know that the board has the ability to do that.
And I can't say I disagree with that because, frankly, I haven't found anything in here that tells us exactly what our authority is. We have the authority to hear it, but nowhere in here does it say, and whatever you say they have to do or whatever. I mean, there's really no direction, that says what our authority does if we decide against or for or anything else. But I think it's fair to the public, since that's who we're here to serve, is the public, is to hear this case.
And I think that's pretty reasonable. And that's why I realized that after the last time that I think I don't want to get off on the wrong foot and say, we shouldn't even completely be here, this should just never see the light of day. That may not be quite the right tone. Maybe that's true, I don't know. And you're right, it's a little quiet on exactly really what the authority is. I just think that is a unique authority that almost no other board has, so it would have to be pretty explicit. I think most of the things, work order that's based on, the type of roof you're doing has to be 8 feet tall, and yours is 6 feet tall, that a stop work order, then you guys can come in and say, that was unreasonable, a roof like that is fine. And that's the normal thing, in which your power wouldn't have to really be all that clearly articulated. You'd just be saying, we think the building official's wrong on that.
Technical code matters.
Yeah, yeah, so.
Yeah, it does.
Sounds reasonable to me.
And I don't want to skew this in terms of getting too far off track here, but Mr. Severn, maybe you could just reinforce your perspective on, there's a decision here about how fees are calculated, and then there's the reality of the money involved. Is there recourse other than the board to recover the money? Would that be a legal step that the appellant would take?
Yeah, you could go to court. I mean, and I don't think that coming here would, I don't think it's like you get one bite at the apple, so coming here would mean you don't get to go to court. I think, but yeah, you could go to court. You definitely said municipalities taking X thousand dollars of my money erroneously, and I want it back, I'm suing.
Yeah.
I mean, there'd probably be defenses to that we would assert of some
Right.
kind, say, but that's a plausible avenue, yeah.
So it might be, and again, I'm maybe going across the line too far, but it might be advisable for the appellant and their representation to let everyone clearly know the perspective of if money remuneration is the final ultimate goal that you're seeking from the board, whether we have the authority or not, or just something that maybe results in clarity of that. But
And the other thing, just while we're on the topic, and I'd like to keep my part of this short, I do think it might be a little different as a prospective sort of thing, where somebody says, hey, the municipality wants to charge me, $8,000 for a permit for this shed of mine, that's nuts. I want to come in here, and then you guys, I think that'd be a little different deal, because you could look at the code and, maybe that type of shed, I don't know, something, but it'd be prospective. I think that's a little different deal. We're not on that topic right now, but that seems a little different than, write a check, but.
So if any, can we render any decision, whether it's advisory or anything else? And are we just gonna hear out, say our piece and give our opinion on the case and walk away?
I think you can render an opinion. I mean, I believe so. Maybe the simplest way to look at it is that if your opinion was municipality, cut a check, and the next week when we get it, somebody calls me and says, what do we do with this? It's a tough call for me. I'm probably going to say, I don't think we need to do it. I don't think they can do that. So, but I think any other kind of advisory opinion or community, go back to the drawing board, check out your policy, make sure it's legitimate or,
And I think the other thing is, from my understanding, with everything that is in code that we deal with, it's a process of our review and a recommendation to the approving adopting body, the assembly. And they ultimately, I think, are the group that has the final say on what becomes code. Is that fair?
that's correct, yeah. I mean, obviously, you can make some decision like, you don't need 6 elevators in that building because the code only requires 5 or something. That doesn't go through the assembly. That's final with you guys.
But the final language of a code and
The code
recommendation
recommendation.
is in our purview.
Right.
Okay. So if there's nothing more, do we want to, at this point, or I should say we at this point should have the appellant introduce and present their case? No, we first hear both sides, and then before we deliberate. we go into a motion. Okay. Ron?
The whole reason why we're here is I'm not asking for direct judgment on a refund amount. What I'm saying is there's criteria set in code that's backed up to allow the building official to write policy, and the policy allows the enforcement. There's hundreds of policies. You guys see them online every day. If this goes down the other way and says this policy is not allowed, then every other one should not be allowed. That's the bottom line. The bottom line is this policy has been in place since before I was building official. Jerry Waite was the first person to sign this policy. There's been many discussions. I've been in probably 50 discussions with the home builders. We changed the policy 9 times over the course of that 20-plus years because it's very important to the building industry to be clear on what unfinished and finished was. They were back years ago paying full fees like the latest proposal by the building official to change the policy is. The whole reason that the building board was that the building community was meeting, the administration was meeting, and the mayor directed the administration to meet, and they went through multiple stages of these, is to get it clear. And at that time, it's very clear in that policy, which is what a policy is supposed to do. Clarify what the intent of the code is based upon what is set up. In valuations, it was very difficult to come up, what does unfinished mean? What does finished mean? Everybody had a different idea what finished and unfinished means. So they asked the administration, including, at that time, I think when Jerry was here was when I first started, and then Ron Watts re-signed it, I re-signed it. It's been in place since many, many years. It all made sense with the home builders because it was like, man, it clarified an issue in the code. Should it have been at some point ratified and gone into code? Yeah, probably. But a lot of policies are that way if you look at them. But the clarification, being able to change those policies is needed by the building official to be able to move forward and hit specific topics as they can. In this case, it wasn't trying to set fees. It was trying to give a reasonable valuation. Many ways to calculate valuation in the city of Anchorage. Residential additions, alterations. Some go to that table in the ICC, some don't. Some just, they used to walk in and just say, oh, it's $5,000. And we'd go, you know, when I was tasked, it was like, there's no way that's $5,000. We couldn't argue it. So, I mean, a lot of times these were clarifications to lock down a valuation for folks so that the city knew what to charge. They couldn't tell us some other figure and all of those things. So, as a building official, I dealt with this many, many times. And we issued permits for that rate, that valuation tied, the fees were always set. This was just a way to calculate valuation. And yes, it adjusts the fee at the end of the day based upon valuation. But there was no arbitrary setting. There was no, it was a full, long public process set up by the administration that the mayor forced us to be in with the home builders, and they still meet monthly. And they still discuss topics like this. And sometimes policies come out, sometimes they don't. If it's a clarification so everybody gets the same treatment, that's what policy is for, is to treat everybody the same. And in this case, the policy very clearly says what you calculate the valuation as. Last summer, when I left the city, I got a job to do a building. It had a basement in it. I calculated the fees by using the form that was provided at the time that now is not the form being given out to everybody. It was revised. The form did not have the 1.3 factor next to basements and unfinished basements because that's what the policy said it didn't include. If you set the 1.3 factor, you got to remember the 1.3 factor as well. It is a factor to adjust a national lower 48 standard to the Alaska rates. So if we set a valuation in Alaska, why would you set a rate just to multiply it by 1.3? You don't need to do that. Nobody in their right mind would think, oh, we set a fee up here, we better times it by 1.3 to get to the Alaska rate, when you're already up here setting the fee. So the old form had it. I calculated the fees to that. I came in with a permit and a check from the owner. The main reason is I try to get the owner to not have to keep going back and forth in what I do now. So it's like, I calculated the fee, I said, I need a check, give me that, give me the whole package. I put the whole package, I come in, I sat down, they started processing the fee, and they said, oh, here's the rate. And I'm like, wait a second, what's wrong? Show me what you calculated. Well, then I found out it was the basement that was calculated at a different rate. And it was exactly that number off. So at that time, the clerk could not process it. They needed to get Gretchen. I went and talked to Gretchen. She goes, oh my gosh, we've never seen that. We didn't know that that was a problem and that was in that situation. And she immediately, supervisory, took that fee off, and they took the check at that rate and went that way. At that time, I said, wow, I mean, how many people are submitting with this incorrect fee in Hanson? And she goes, well, geez, obviously probably everybody that's applied for a permit, besides you, Ron, who calculated the fee yourself and knew what it would be when you came in. And I was like, well, I go, with that, Gretchen, I work with a client that does basements. I go, it's only fair for me to then ask for some of these refunds back for incorrect, erroneous calculation of fees in the computer system. So I took a little while. I was going to do a research fee, but I just said, heck, they can easily find that number. They can do a query in Hanson real quick to find out what builder has what basements and calculate that in a short period of time. So I just filed for and said, for the 2 residential builders that I'm billing for, I think it should be done for all builders. I mean, I think it's only fair to refund the people, every person that has paid over fees based upon this situation. It is what it is. I think that I can't disagree with the 2-year increment, because we settled the other case and we settled that basically they paid back 2 years worth of the unused inspection. So I thought that was fair, and I think that the municipality saw it my way and that way, but it couldn't go back any further, and that made sense, and I think we're in agreement there, and we solved that one. So the same thing here is, I think from the date that I applied this November, I think it's only fair to go back 2 years from that November and refund. I only filed for 2 companies, but I think it's only fair. It's not right to collect fees incorrectly. You're the municipality. The municipality should be above board, should be doing what their policies and what their code says. And if they don't like it, change it. That's what I've always said. That's what I've always done when I was there. I think if the policy isn't liked, maybe it's not understood. I think it's not understood right now based upon what it was. And yeah, my name's on the bottom of it. It's kind of strange to have my name on the bottom of it. I'm fighting a policy that obviously I felt strongly enough to keep it going and sign my name and continue it on. But what I didn't like about this process was all of a sudden I get a letter that says, oh, no, we should be charging this, it's wrong, it's incorrect, this policy's gone. Well, then I provided the mayoral policy that requires 30 days notice, and it required 30 days notice to make this policy into play. So, I mean, everybody got the choice to, both sides got the time to input to get it there, and both sides should get a chance to input on the way out. Instead, the documents just start changing, the policies ripped off the website, and it's like, man, what did then I get a letter 6 months later, it was submitted in November and got it in May, that said, no, sorry, the policies are null, void, it's not acceptable to be able to do that policy, and that the valuation, you've been being undercharged for years. And I'm like, no, that's not what's going on here. The issue is the policy was in effect, just like every other 100 policy. If the new building administration doesn't want that policy, then they've done that, and they put that out for 30-day review, and I'm pretty sure that home builders are going to have a very big argument against it, because they're very strong in creating that policy. And so it wasn't there to set fees, to set things like that. It was there to clarify what unfinished and finished were like. And you can tell in that. It tells you exactly what you can do in a finished to call it finished. It tells you what you have to do to be able to get away with calling it unfinished too. Because so many people were also doing unfinished business permits and then not paying the fees for a basement. They were just renovating it on their own. So some of it was creating a fee to the value that we weren't losing those, and we were getting the permits for those and getting people to come in and actually, get the inspections and do it right. That, sometimes there's fees set like that are, because if it's a tenant improvement inside a house and nobody sees it, they're going to just do it unless it's reasonable to come in and do it. And that's a lot of the remodelers were the ones that helped come up with this finished basement fee and all these different changes. And then eventually we went away from those, and they're doing, by inspections now and all those type of things for tenant improvements. So there's a lot of differences in the code. And maybe the policy is, maybe they're not building as many basements or anything. But the issue ends up being is, I'm here for the integrity of the process that's set up. The process was set up, the process was clear, the policy is clear, the policy helps clarify what to charge, because there's so many different ways, and it wasn't all the ICC code table that is used. It's used many different ways to calculate fees. And so to just look for that and say, oh, we have to use that value in there, no, we don't. We don't use it in many things. Even till today, they still take on a tenant improvement, whatever a person gives you as a value for the tenant improvement, they still take as a valuation. So it was setting a valuation, no different than anything else, not real, and the fees are all been set based upon that valuation. And the fees were calculated and made sure that the municipality made money at the value that those fees were done and calculated. And so the main thing with that is I wanted to point out the facts that I believe that the policy was existent from well before when I wrote it, well into when I started with the municipality was there, but I've been in meetings for 20 years plus on these topics, and I think that it's important to keep the policy process in place and the policies handled the way that they are. I think it's very important that you know that it wasn't just set up by the building official, not just by one, it's signed by multiple over the years, and it was helped by the home builders trying to get straight fees. I think that it's also noted that, you know, the change of this policy and all these things real fast, a lot of people didn't realize this mayoral policy was in place. I had to point it out before, and then they put it out for 30-day review. Otherwise, it was just changed really fast and taken off. And I think it's important to keep those things in play. I think the old use, the old back of the permit is pretty clear. It wasn't times 1.3. The new one is very clear. It's times 1.3. It changed, and something changed. They chose to feel like it was different. I mean, different administrations do things differently, but I think that's why policies are important. That's why code's important. The policy is there to help the next person in line make sure that they keep clarifying and using the code the same, or change the policy. And that's what I've said in this case. If you want to change it, change it. But don't change it in the middle of it, and don't enforce it and just change it and say, it was no good, we don't want to use it, and we don't want to adhere to making sure that we build correctly. Because in this case, I feel they completely have misbilled when Hanson was developed. Somebody in Hanson, obviously computer programs, when you calculate numbers, it's garbage in, garbage out. Whatever somebody put in, you can't use that as an argument that, oh, Hanson was set up that way, so that was correct. It's just, the policy was there. The policy was clear. It wasn't programmed in Hanson correctly. And therefore, the increase in fees that no one caught since 2011 have been going on. And that's unfortunate, but it's the fact that before that, they've never were charging the 1.3 times it, and they were using those fees, the valuations as I depicted. The code is very clear that in 2310-103, in the presently adopted code, that the building official can set policy and procedure, shall be in compliance with the intent and the purpose of the code, and shall not have the effect of waiving. This wasn't waiving anything, it was trying to clarify. The previously adopted, the one in 2009 said the same thing, the one in 2000 said the same thing, every administrative code says the same thing. It's very difficult sometimes for, you know, as an administrator of the code and dealing with attorneys, and especially in the municipal attorney's office, because a lot of people don't understand the power the building official has is immense. It's very strong. It's very, it can't be, it could easily be abused, but it's got to be strict. It's got to be enforced to everybody, and you got to do it the same. And you got to try to make sure things are clarified if they're not clarified. And that's the whole intent of doing that. And that's what I felt I did. And I feel that everybody that is, you know, is or currently in that position try to do. In this case, I don't think that Kent had all the facts associated with how this policy got developed, how the codes work. He hasn't done that all the time. I did reach out and say, hey, can we meet on this and talk about it? He just said, let's just go and deal with it at the building board, and that's fine. That's a prerogative. I would meet with people up until the meeting time to see if we could settle things, trying to not have to go to the building board and get an appeal, but try to settle it based upon what the language says and follow the language. And that's all I'm asking here in this case. I also feel strongly that Hanson was just programmed incorrectly at the time, and it has been for 5 years. And yeah, okay, people haven't bitched a whole lot, so okay, that's fine. You can change that policy maybe and let it go now, but those people that filed under that policy's reign should be entitled to the erroneous fees that they paid. And I I've already talked about the valuations in several cases. I can agree with the 2-year scenario with regard to that. I think it's more than fair. I mean, I'm not trying to, I don't even, in this case, both builders don't even know I'm applying for this for them. I did ask them both how many basements that they built, because I said, were you under the understanding you were overpaying permit fees? Both of them said no. One builder said he approximately builds 10% a year. They build 75 homes a year, 10% that has probably basements in it, something like that, to that effect. So I felt that it was strong enough to not just get the code changed or make sure it stays in place, but just make sure that if they're paying erroneous fees, the building safety fund is set by itself. The funds should still be there because it's all stays in the building safety fund. It doesn't go to the municipality and the regular general fund. So there's a little difference there too. The fund's there to do the work that they were paid for, and it's supposed to be break even. If they made too much because it wasn't broke even, then it's not right and it should be going back to the folks. Same thing with unused inspections, same thing. It's all about trying to break even on that. So anyway, the scenario that I'd like to see here is the fact that, yes, the policy was in place. That's the judgment, and the code supports the policy, and the valuations are set based upon the policy. Therefore, the building official, who can issue refunds by code if they're erroneously collected, can then make the determination to do that and refund them because those policies are in place, and the policies are in place. And it's too bad that we're arguing this fact, because if the decision is the policy is not in place, boy, that means that would disrupt the entire operation of building safety with regard to the 100 policies that are online right now. It basically render the same thing, that they're all null and void as well, because that's what you'd be saying if you don't say the policy is in effect. And so that's where I want you guys to understand and decide, and then move forward and let them make the decision on the amount, but make sure that they understand that, hey, the policy is in place, the code was in place that allows the building official to do it, and so on.
Thank you. At this point, if there were any specific questions of the appellant, it would be appropriate to maybe run through these, and then we'll hear the case from the municipalities beside. Any questions of Mr. Thompson?
So, at this point, are we talking,
Excuse me, I thought they're supposed to present, then I get a rebuttal, and then we ask questions that we can ask for both sides.
Well, I think I presented it this way. If that's a procedural error, I guess we can follow it in that manner, but we did break away from that and did have questions of them following our introduction. Well, what's your perspective? Would you rather we... Would you rather we not ask
No, that's
questions
fine.
at this point?
That's fine.
We hold questions now so we don't obtain it. We can deal with these questions after the municipalities.
that's fine with me?
Thank you. So at this point, the next item we have is staff presenting municipalities case.
Okay, thank you. So I'll start, and others may chime in. First, I would say we don't dispute much of what Ron has stated with respect to the history. I would also say that when the previous acting building official took a close look, Sharon Walsh took a close look at this, the initial look, our impression was that the municipality had been overcharging, and that we would likely make a refund for those overcharges. But as we looked into it, the code path, which is outlined in the municipal staff packet, became clear that our impression, and we believe Ron's presentation or Ron's appeal, is incorrect. A couple things that I would say before I get into the details of that. Ron stated that if this policy isn't held to apply, that no policy would be held to apply. We don't agree with that. The discussion on this policy in particular is that, in our opinion, it has the effect of setting fees, which is reserved for the assembly only. So we are certainly not taking the position that any other policy that exists and is used on a daily basis would be null and void if this policy is found not to have been accurate. So going through, and I won't read the whole packet that I presented, but going through the argument that we've laid out, I think some key points are that Anchorage Municipal Code Chapter 3 has a definition of fees, and I highlighted in there is the amount established by code. It goes on to say in Chapter 1 that unlawful for any person in the municipality to alter code. And alter is alter or tamper with code in any manner whatsoever except by ordinance or resolution or other official act of the assembly. So our position is that because the codes are set, the fees are set by code in Title 3, that changing code without the approval of the assembly would be in violation of Chapter 1. I think Ron read out of Title 23, and I think I put the same paragraph in our write-up. The building official is authorized in Title 23-10-103.3.1, authorized and directed to enforce the provisions of code, render interpretations, and to adopt policies and procedures. So clearly, the ability for the building official to put policies in place exists and would not be voided by this case, no matter how it's decided. But that section goes on to say that the interpretation shall be in compliance with the intent and purpose of code and shall not have the effect of waiving requirements specifically provided for in this code. So our position is different than Ron's in that we see a clear code path between Title 1, Title 23, and Title 3 with respect to the definition of fees, how fees are created, what municipal body has the authority to create fees by code, and the authorities of the building official. When we look at all those, we don't see that that the building official has the authority to alter or change fees. And in our opinion, what was done with this policy years ago, and it's unfortunate that it's carried on this long, but what was done by setting a valuation that is in contravention of code, because code specifically talks about where valuation comes from, which is the documents I attached to the back of the write-up, the building valuation data charts. Code refers to those. Those charts are silent on finished basements, so the clear conclusion we draw from that silence is that a finished basement is finished living space, which is category R3, 1 and 2 bedroom homes. In category for group 5B, there is no other discussion of basement space other than the note at the bottom that refers to unfinished basements. So given that the building valuation data charts spoke to a value for unfinished basements and are silent on finished basements, the only conclusion we can draw is that the valuation for a finished basement is the valuation for finished living space for a group R3 occupancy. So I'm probably missing some points, others can jump in, but when we weave all that together, for better or worse, the fact that this policy's been in place for below these 16 or 20 years, we believe it was an error, and we're moving to correct it. Now, Ron did talk about, and I take responsibility, we did pull that policy immediately, and we shouldn't have done that. I was aware of the 30-day policy, we just we overreacted or improperly acted. We do have that new policy out for review now.
Well, correction, though, we haven't changed anything. People are getting charged for basements today what they got charged for basements 3 months ago and 3 years ago.
What about 6 years?
We put the policy out for 30-day review we revised the policy and put it out for 30-day review last Thursday.
It was on the website, and there was a blast as well.
I guess I would close by saying I had a case recently where a nonprofit asked me to waive a fee. And if there's ever a reason to waive a fee, it's for a nonprofit that provides health services. The advice that came from the Department of Law and the administration was that the building official didn't have the authority to waive that. So in that case, they went to their assembly representative, and an ordinance was introduced to specifically waive the fee for that. So that would be an avenue available to the home builders, would be to to bring forward an ordinance through assembly members or working with the board to try to address this, but we see this as, although unfortunate, a clear case of code supporting the position that we presented. That's all I have. Anybody else have anything?
So at this point, we go to the rebuttal from the appellant.
And I would say I strongly disagree with the fact that when just because it's silent, you just get to pick anything out of the ICC table and call it good. And that's what the policy was there to do, was to clarify what unfinished and finished means. It wasn't in the table. I don't think either one of them were in the table back 20 years ago. So we clarified that. It never got noticed, obviously, in all of the code changes, that finally unfinished basements got a category in that table. That category is still, I believe it's 15 or 20. So it's the same number that we've been using up here forever. But it still doesn't say finished basement, and it still doesn't declare all of those different specific requirements of what you can and can't do in a house to call it a finished or unfinished basement. I believe that policy, anybody right now can walk in and say, hey, I'm going to do this renovation at this valuation. They don't get set in an ICC table. They just set the valuation on arbitrary number, whatever they want to do. It's not set in code that you have to use the ICC table. I believe the ICC table also says it's up to the local jurisdiction having to adjust and modify it. And that's what they've always done, is modify that 1.3 factor. But it's like they can adjust that table. It doesn't say that you have to use that table. And in a lot of cases right now, we don't use that table. For half the fees that are calculated in the city are not done out of that table. So in this case, I completely disagree. I believe the policy was set for one reason, to clarify code, to clarify what can be done in those categories, and they did not have a value in the ICC table. Therefore, it clarified a value that was just given to be able to meet what they felt was a strong argument for the value of what it does, because they already have to dig the foundation. They already have to dig that. So the whole argument was to try the fact of putting in a basement on top of a regular building is it costs less, because you already have to do all the excavation anyway, whether you do a crawl space or you dig some more half basement or whatever it ends up being, daylight basement, all those different things. But the scenario ends up being is I just completely believe that the valuation was trying to clarify the code. That's why it's been there. It's been there for 30 years. Ross said 3 years ago it was charged that way. Yeah, because Hanson was in place 3 years ago and it was charged incorrectly. 6 years ago, it was not charged that way. Prior to Hanson going, it was charged out at the rate that's in the policy. Hanson just came in, they just threw 1.3 times every factor that was in there. Therefore, that's why it jumped up. It's just it is. I agree with Kent that it's unfortunate that it seems like there's an error. I don't believe there's an error. It's not. It's fortunate that there's clarity in what goes on in policy. And I believe 100%, if you ask Gretchen, they've calculated without that fee prior to Hanson. Is that correct?
Yes.
Yes. For how many years was that prior to, when was Hanson put in?
2011.
2011. So therefore, since 2011 is the only time they've been charging that fee, and it was erroneously added at that point in time, or they should have evaluated that table, got rid of it, and went into something else. There was a clarification, it was put in. It's not setting fees, because everybody gets to walk in and set a fee based upon some valuation out here. But this clearly just said, here's the valuation. We're not letting you we're not letting you call it any other valuation. Here's a specific number that you're going to use. Fees were set according to that. When the fees were calculated and I created the fee structure that's here at the city now with all these percentages and all that. It was set based upon that number to break even. That's what it was set on. At the end of the day, they have the prerogative to remove that policy, but the policy was in effect when we're talking here, and to me, the policy is in effect. The policy, if you take and say that the policy can't change code, how many policies do we have that are different than what the code specifically says? A lot of them. Almost every one of them. Right? That's why there's a policy. Ross?
No, I don't agree with that statement.
You don't agree that most of those aren't code
I don't think
requirements?
it's appropriate to have this,
No, you,
this dialogue.
actually, and the thing, we have the ability to ask questions that says that.
No, it's not directly like
Yeah.
this. Not, the chair can stop that, Ron, and I'm stopping this direct question. I think it would be behooving the three panel members to follow up some questions with that. But I think the intent is not to have the two sides debating something in this manner.
I read the building board differently than that, but that's okay, I understand. But I just think completely in this case that the policy was in effect, and the policy was valid. And with that, there's a lot of policies in the city that are code related, that we do because of Alaska extremes, different things, and the policies stay in effect, and they've been in effect, and some go away, some come, but there's policy in there that allows you to directly do something different than what the code says. And I could point out all of those, but there's many of them that are.
Okay. Do you have anything further to add that hasn't been already stated? Thank you. So at this point, we've heard from both sides, and we would open up to questions of the panel. And then following that, I'll be seeking a motion relative to our deliberations.
So, Ron, for clarity from here, we're really only talking about finished and not unfinished basements, because it has become clear to me that the fees, whether they're charged with or without the 1.3, is lower than what you guys had it established from the beginning, as near as I can tell.
Say that again?
So right now, you have in your paperwork that all unfinished basement areas shall have a construction valuation calculated at $20 a square foot. Right now, they're established at $15 a square foot with the 1.3 factor. Added to that is $19.50. So that's under what you guys had it established as. Is that correct? So we
I
don't even,
believe it's set at, whatever the policy says.
the fees are 15.
15 is what's in the tables or policy.
Yes, correct.
Okay, so that's off the table. I mean, no
Correct.
one's been overcharged, if anything.
They've been
everybody's
undercharged for
undercharged a little bit.
unfinished.
Okay, so then we get into,
If, that is, if Hanson's number's not at 20, if Hanson's number's at 20, then, or at 15, you're correct. If the Hanson number is at 20 in the system, I don't know what's
well,
behind the system.
if the.
I don't know what's in the back door of.
Can you guys
So
tell
maybe, if I could we get a comment on that? Do we know if Hanson is using 15 or 20?
15 and 20.
20?
So it has been over. Does that,
So-
that's what I believe was the case too. This form is wrong.
Yeah, I believe this one's a 1.3.
It's being calculated as 20 times 1.3. So it's being
See
used.
that, there's, on the May 25th letter on the back for official use only, it's entering unfinished basement $15 times 1.3.
Which is the 1950, and I think it's rounded up to 20 again.
Right, okay, so it's,
Yeah.
but you don't add the 1.3 on top of 20?
Yes.
No,
So,
Oh, okay,
No.
that's, right.
not on top of 20, no. On unfinished, no. It's on top of 15.
Right, 15 times
I-
1.3.
I just get that checked because I don't know if it,
For unfinished.
I thought we looked at it was at 26,
Well, then that wouldn't be.
which would be 1.3 times 20.
Then that wouldn't be holding to the BVD. If that's the case, and my understand is that's what Hanson comes off of. So then that would be totally wrong if that's the case, but based on what I'm seeing here and based on the document that you provided and they provided, it said 15 in both of them. Yours had not the 1.3 factors, but there had the 1.3 factors.
I believe it's being billed out at $26 a square foot, which is 20 times 1.3.
No.
But,
I
I
just,
mean, I
no,
thought we checked that, but
not unfinished. Finished.
and if
if it's 20, I 100%.
if I might, just to agree, so the Hanson program does the round-off factor.
Yes, rounds
So
up.
we find that in all of these tables and values. I do have a follow-up question to that.
Okay.
And, pardon?
You only have a moment, Ken, for your thing.
Ken, would you like to?
I was just going to say, if, we'll look into that, and we'll make sure that if the Hanson program is incorrectly calculating 1.3 times 15, we would correct that.
Okay. And just to keep this in a orderly process of back and forth, Mr. Thompson, as the appellant, would you agree that if in fact that 50-cent difference exists, would you, are you supporting that those people pay the additional 50 cents a square foot for all these that occurred?
Say that again.
The difference we're talking about, one, we gotta check if we're using 20 times 1.3. Everything that I'm seeing in the tables and all and on the charts is indicating we're using 15 multiplied by 1.3. The difference is then 50 cents, correct? So my question is, you're making an appeal to rebate for people that have overpaid. Is your appeal also supporting those that have
Actually-
underpaid be charged?
That would be fine.
Okay, thank you.
I mean, that's,
And if I might, then the other question, so we can kind of, as the board, as we deliberate, would you agree that a precedence has been established on a 2-year look back relative to this, and this is all that is really the perspective of our dealings?
I mean, it sounds like that's a legal discrepancy. If they find out that it's completely been done, I mean, they can either make the decision to make everybody whole for the 5 years that Hanson's been incorrect, or hold it to the state statute of being able to sue people for 2 years. I mean, there's two different things there, if I understand it. Isn't that right, Sam? There's a 2-year that you can actually go after somebody for, but there's the other decision of, is if the municipality really made a mistake, would they make people whole, or would they just stick to that 2 years, or go all the way back that they were erroneously doing it? And that's, I mean, to me, I mean, if their decision in this case is that, yes, the policy's in place, I mean, I would hope they did the right thing, but I guess we'd have to settle for the 2 years at the worst case from November date.
Mr. Severin, would you advise us to narrow down our deliberations relative to that 2-year look back?
Yeah, I think that's pretty reasonable. Again, in the context of the fact that I still don't think you can award money, but hypothetically, yeah, I think 2 years is a limitation. That's a pretty standard state statute limitation for just about anything that, I mean, there are other statutes limitations, but for something like this, if you wanted to sue, it'd be 2 years, so that's something
Right.
we've used to.
And I'm not saying that we're going to make the decision on that, I'm just trying to maybe get my arms around what we're really potentially dealing with here.
Yeah, I understand. I think 2 years is the best that the state statute would apply if somebody were to sue.
Thank you.
I have a question, and I think I know the answer. We're in the question and answer period.
Yep.
And the procedure for the board allows for presentation and then rebuttal by the appellant. I have a couple comments I'd like to make in response to what Ron, or in response to his rebuttal. I don't know if that's appropriate, but I thought I'd ask.
I'm sorry, I'm out of sync here, and I don't have the agenda or the rules in front of me. So relative to our procedures, at this point, we should have had a rebuttal period.
No, I don't know that the procedure allows for a rebuttal to the rebuttal. I wanted to offer a couple clarifications, but I thought I'd ask before I launched into it.
So we've already done, the appellant has their rebuttal. But that would be following questions we have.
Right.
So once we get to these rounds of questions, the appellant has the rebuttal, and then we go into our deliberation. Is that fair?
So if possible, I'd like to make a couple clarifications, but if I've lost my chance, that's fine.
Well, I think this is an important enough issue that we get a lot of dialogue on it. So as the chair, I would like to ask Mr. Quillhouse if you had any additional questions or clarifications that you.
A couple of clarifications based on some of the things that Ron said. The first one I think I mentioned, but I would mention again that our opinion is that because the building valuation data chart speaks specifically to unfinished basements, yet is silent on finished basements, we can only presume that the crafters of the document envisioned that finished basements would be second bullet, the square foot construction cost is not included in the price of the land. I'll skip some of it. It goes on to say it takes into account everything from the foundation work to roof structure and coverings, but does not include the price of the land. The other point I would make is that in Anchorage Municipal Code, Chapter 2310, 104, 15.1, valuation, it specifically states how valuation is determined, and it specifically refers to the building valuation data chart, and by code applies the 1.3 factor, so that's where the 30% comes from, is from code. And then the last thing I'd mention, Ron mentioned renovations and remodels, and the building valuation data chart actually talks to that in the very first bullet on the top of the page. The BVD is not intended to apply to alterations or repairs to existing buildings, and it goes on to say because the scope of that work can vary so greatly. So I think the crafters of that document and our adoption by code clearly envisioned that it doesn't apply to renovations and remodels, but it does apply to everything from the foundation up. Thank you for the opportunity to add that additional information.
Any further questions? Mr. Thompson, I think you have the rebuttal right.
I think it's really unfortunate that it's being completely taken out of context in the sense that this policy is 30 years old. The codes have changed drastically over that period of time. This policy was reviewed and revised many times. It was very much felt by more than just one building official that it was very easily set as evaluation to clarify what it says in the code. Otherwise, the policy wouldn't be there. Otherwise, it would have been eliminated one of the 10 times that it was rewritten because there was obviously a need. And that out of all the policies, it's very few of them that have been renovated and re-gone through that many times. That policy, there was a major intent for that policy with regard to construction in the residential community. It very much was created because of enforcement actions, inspection actions, all kinds of actions that were gone. And each time it was renovated because somebody was trying to get around what it would be. So it was always made more and more clarified. That policy is very clarified. It was very much enforced, very much went through the system, very much fees associated with it were paid under that policy for 20 years. And then all of a sudden, when the Hansen program is reprogrammed and programmed incorrectly, now all of a sudden it's illegally set. I take real offense to the fact that basically saying that it was a policy that can't be under the purview of the building official. I completely disagree with that statement 100% vehemently. As a building official for 15 years, if you didn't have the ability to write and clarify sections of code, you would never get your job done. It'd be very difficult to do it. That's why there's policies. That's why there's enforcement actions. That's why things go on like that. That's why when I noticed this and it was charged incorrectly, then all of a sudden the forms start changing and all these things start changing. It's a sign that it wasn't that way. It wasn't intended to be that way. All of a sudden, though, we got to change it and make these forms have the 1.3 on it and make all these different changes. And I think just the vision of that is very poor from the public side, especially after holding that position for so many years myself, that I really felt that type of stuff I could never do. I may not have liked that, and I would have dealt with it, and I would have paid, but if I found it and we didn't agree, we'd have went through the process and changed it immediately, but we would have enforced and allowed what was in that until such time that it was taken away and revised. And at that point, that's kind of how I still feel. I feel very strongly that this case is so easily clear that it really hinders, it's gonna, it makes it very difficult. Every time somebody asks a question about a policy, is the policy just gonna be eliminated and say it's no good anymore? It sets a bad precedence to start taking away policies without a 30-day thing and enforcing them and changing the way they're enforcement with how they're written. I think it's really a slippery slope that you get to, and that's not what the building officials supposed to do. It's supposed to be clear and fair to everyone, the same with the written documents. And I will say that on any issue that we argue on this type of thing. Policy was there. If you don't like it, could change it, but you gotta enforce what's there. And that's what's there at the time, and that's what I strongly, strongly feel and strongly urge you guys to hold up that thinking with regard to this process. Because if we lose that, it's gonna go downhill in a lot of different ways.
Mr. Conley?
To you guys, number one is, I think, I'm listening to what he's saying, I think you're agreeing that the, pulling the policy and making those changes wasn't,
What, you made a mistake, you bet.
I made a mistake. So, you're right there, and I think we're not gonna do that anymore. Right. So, the next thing is, when I listen to you about this, original policy, I see two things happening in this policy. One is, it is a very good policy on clarifying exactly what finished and unfinished is. I think that's a good part of the policy. The other part of the policy, I'm a little foggy on what it's doing. I feel like it's not very clear.
We'll use electrical.
Electricians know what to do.
You have the power, I have the power.
Start waving your arms. I feel like then it addressed the cost per square foot in this policy, which is unclear if it was filling in the gap for a lower 48 cost that needs to be multiplied by 1.3 or not. It doesn't have any way for escalation, for inflation. These numbers seem extremely low. So I feel like as far as this policy goes right now, just in my thought process, I feel like it could have just as easily been set that this is to take the place of the table, and then it's put in, and then multiplied 1.3. In my mind, I can come up with a scenario where we've been undercharging all this time, and that we should have had the 1.3 times these numbers. They're very low. But maybe in 19, whatever this happened, it wasn't low. But there's nothing here clarifying that this is an Alaska price or Alaska cost.
They've been adjusted over time. The policy from the beginning is a different number than.
Does it ever state that this is the lower 48 or Alaska actual cost?
Does it vary from the ones we
Yeah.
received copies of?
Yeah.
Going back to Mr. Waite?
The very beginning had lower prices, had lower value, 13 or something.
Through the chair, the first one had a different calculus, but the second one was $50 a square foot, and it's been that ever since. And what's the date on that one?
March 25, 1997.
Yeah, I see him now.
Yeah, so since 97.
Wait, I apologize. The 1997 policy, just looking at it, appears to be silent on a cost or valuation for finished basements. The 1999 policy, June 21, 99, established the valuation for finished basements at $50 a square foot.
I think it's very clear that until 2011, it wasn't multiplied by 1.3 in their table, in their thing, so the people that wrote it are in charge of setting the clerks in line and getting it set. It was very obvious the 1.3 was not a factor because it was set in Anchorage. Why would you adjust a factor that you set in Anchorage for an Anchorage adjustment? It was that way, and it was processed in the system in PAS, the old PAS system, everything, from day one until 2011 when Hanson came into play, and that's it.
If I might follow along with your question, Mr. Kelly. So we have this issue of the policy being established, and I've sat in on a couple of cycles of code adoptions, and one of the goals that I've heard presenting as we all get together is, because there used to be a term of a salmon book with the fire department, it was this unknown document that was often used to establish things. There were policies, but what I was hearing is when you can take policy and put it into an adopted code, that it serves everyone the best. So I guess I'm throwing out the question of why we're not seeing these policies updated, or why maybe you didn't, Mr. Thompson, move on that if you felt strongly about these in terms of bringing them into code. I think the policy does speak to a definition, but you certainly can add definitions to the code. And the valuation can be added relative to these charts. So my general question is, why do we see these policies last forever and ever and ever, and then they come back maybe to haunt us in some instances? Is it a timing issue? Is it,
There's many issues in here that were changing. It was being done every couple of years, and the code cycles go on. It was just always being renovated, so when things are being renovated, you try to get to where at certain times, it was incorrect at certain times, it kept being adjusted until it's finally handled and addressed. I mean, all I can do is when I was there, it was very clear to clarify an issue. It had nothing to do with trying to set fees, it was to clarify and make it simple. And it made it simple, and our headaches for unfinished and finished basements went away. If this policy goes away, the headache will be back, and it will be in a large, it's a major, and I think no matter what, the home builders are going to be presenting against it in a pretty strong way, because they believe it's worked for 20 plus years.
And the position on the Muni, would you see something like this, Mr. Kohlhaas, moving forward with maybe through action with the assembly, becoming less a policy and more codified?
From my perspective, after 2 months acting, and hopefully not much longer, is that, yes, it would certainly make sense to have this clarified and codified. I think it would be better for all parties.
Through the chair,
Mr. Mouse?
we're not proposing to get rid of the policy's not going away. The part of the policy that clarifies the difference between finished and unfinished construction is legitimate,
It's important.
and it's important, and it's gonna remain. We tweaked it a little bit, because we thought we clarified it even better.
Yep.
But what we did get rid of in the policy was the fee, was this category of construction that the policy created. You know, the code, this thing's 20 years old.
Yeah.
The ICC, the code bodies have had 20 years to add a category called unfinished basement to their fee table. And every 3 years, they had to bite at the apple to do it.
Right.
But they didn't do it. So, we feel our position's pretty reasonable.
Okay, thank you.
So we have a unfinished basement now, but what we don't have is a finished basement. And I think that back when this policy first came out and when Ron was still working with it and everybody was working with it until this thing just kind of popped up in everybody's face, right? I think there is room for when you know that there's an area in the code that doesn't exist or doesn't work like a finished basement. A finished basement certainly does not cost the same as the house. No doubt about it. I think everybody at this table will admit to that. I don't necessarily believe that it's $50, but I definitely don't believe that it's worth the same value as the house. And I think as the code officials, they need to recognize that, which I think a lot of them did and tried to do something about it. Obviously, there was heavy influence by the residential builders to make it as low as possible. But I still think that there's a place for it. I still think there's a place in the code and a fee for finished basements that shouldn't be charged at the same rate as the house itself. I'm still very strongly about that, because it doesn't cost the same. So I think that, I mean, I don't think this policy, I think the policy was drafted and been around this long just because it did serve a purpose, at least for the residential builders. And it just took this one instance for everybody to kind of shake their head and go, okay, well, what's been going on? And is it right or is it not right? I mean, it seems to me the biggest issue here right now is the act of a building official setting a fee, evidently. Evaluation for construction. But if it doesn't exist, how do you deal with that? I mean, it's better than overvaluating and charging them much more than they should be charged when you know it doesn't cost that much. So, I mean, and I think that, what do I want to say? I mean, when I read what you're talking about, I mean, it seems to be pretty clear that the authority isn't with the building official to set the valuation.
I may have sent us down a path, but these are great deliberation topics.
Okay.
Unless there's a specific question.
No, there wasn't.
Okay,
So I think it's time for a motion.
yeah,
I motion that I go to the bathroom first.
okay. I'll take a brief break.
Thank you. I didn't know that was allowed.
We made a mistake.
Say anything about potty breaks.
We can write that in there, you know.
Yeah.
She's coming back.
So you have a good supper?
Yes, yeah, we're not very busy, so I'm like, it's like being a regular human being where I take time off.
Yeah.
I go home and it's like, I get home at 5:30. I never did that before.
Everyone's going through
I actually had a neighbor come by and go, I didn't know anybody lived here. I'm serious.
You know, the Assembly's crafting an abandoned derelict building. Better mow your grass.
I have a gardener, and I have a maid, but, yeah, he's like, I've never seen anybody come or go here. I'm like, yeah, I just come and go really late, because I was
Yeah.
working, you know. But, do you know Andy Weiss and Alicia Weiss, they work over at KPB?
No, I don't.
They're architects, they're having a house
Yeah.
built, and, they needed a place to stay while it's being built, so they're living with me, so now, I got people, I got 2 kids and 2 dogs, and
Oh.
shit, man. So it's kind of a big house, so I don't really notice them too much, but whew, that's different.
You're single?
No, I'm married, but my wife doesn't live here, so I've been living alone for 5 years.
Yeah, that's a big
and
change.
yeah, it's really huge, so all these people, I go down in the kitchen, there's always people there.
Yeah.
I feel like I'm in college again.
Yeah.
It's really good.
Especially with kids around.
Yeah, yeah. But the kids are actually nice, unlike mine. My kids are not that nice. They're really nice. I'm like the crazy uncle. Are you gonna come up with this motion? You're really good at those. I've heard you do it before.
Go to the bathroom.
Before now. I've heard better ones than that.
So you written it on your hand?
Yeah. You don't wanna watch the
That's
sausage
on the
being
wall
made
in there.
there.
It's on, yeah.
I have to go back and
Yeah, you have to go back to the urinal and look on the screen there. Stick my Sharpie in there.
You guys can go into executive session to track your emotions.
We may, once you guys sit over and go,
This is
ah!
off, isn't it?
What do we need to make this motion, how do we need to craft it?
Well, I think basic suggestions are to always form a motion that's in the positive, which would be first to support granting the radio.
Yeah.
And then from that, modify it through amendment and/or discussion.
Oh, no.
But, you know, if, this weekend, I just never dealt with it being an outright say, if you started with a denial, but certainly could. It's just that we need to make sure that we're stating This one's
Is
too
D
long.
pretty good about that?
We'll find our way through it.
Yeah,
This year,
it's-
just say, reason for it. So, is everyone back and ready?
Yes.
Tana, I said that when you're farthest away from the machine, so.
No, we're on. Go for it.
All right, we're
Chair?
back in session. Before we hear a motion, there's one additional follow-up question. Mr. Powell?
I have a question, that, is the new policy or the idea going forward, are we going to eliminate the valuations established by this R.01 policy with the 50, the 20, or 15, these numbers? Are those gonna come out of the new policy, and we're gonna go strictly to the IBC table?
Correct, through the chair, yes, we're gonna delete the numbers out of the policy and just, and say the fees will be in accordance with, 2310 Anchorage Administrative Code.
Okay, and then is your assessment of those square foot valuations in the IBC, it seems reasonable to me that you could say that if you have an office space valuation for a building, you could make this argument that if it's a two-story building, that space doesn't cost as much to build as a one-story. If it's a 50-story, you could make the case that maybe, I mean, there's ideas about depth, so assuming that, so I get your point about the basement does cost less, but where do we stop that splitting of the hairs? I kind of feel like possibly, and I don't know how these are done, and I'm looking to you for maybe some input, are those average costs based on, they looked at houses and they said, okay, houses in general, when we do the square footage, this is what they come out to be?
Yeah, it's based on houses and duplexes, or?
Well, it's all different types of construction. It's based on occupancy classification and type of construction.
So is it safe to say that possibly they look at the ones with finished basements in their numbers, and those numbers already average that in, or?
I mean, we're just making assumptions in terms of how they came up with the data. I couldn't tell you exactly how they came up with the data.
But that might be part of research you do as you modify a policy.
And so per square foot,
Better understanding maybe how they are
Yeah.
residential.
Help to write it, I know what it is.
Mr. Thompson has his hand up.
Just a second, Mr. Thompson. So is it fair to say that there may be some follow-up to better understand these residential values, or not necessarily?
No, not by us. If people want to change fees, they could, propose an ordinance and go through the assembly, but, yeah.
Okay.
so this policy's being put out to, I saw it come in an email, I actually didn't read it, but is the adjustment now going to be that it won't look like this in Hanson at all now? It'll now use this 112.65 times the square footage?
Correct.
For finished basement or?
Yeah, correct. It'll take just the finished construction value times the 1.3 multiplier.
The reason it was set lower is because 90%, probably 95+% are left to be finished by the homeowner. But if they drywall the walls, then they can electrical and put that in. So they basically have an empty, wide open basement with drywall on the walls, that's it. No trim, no finish, no walls, no, all these different breakouts. That's why the price was lower. Some might finish a basement, but the whole discussion wasn't because, they're not finished, these basements, the reason why basements are most of the time built is because an owner can get a little more square footage without a whole lot more cost because they're finishing upstairs but not finishing downstairs except for drywall. It's considered finished, but it wasn't a full finished out with walls and bedrooms and closets and all those scenarios put in. All that comes at a later price with a permanent tenant improvement, which they're supposed to get. But this allowed the drywall and the electrical to kind of get put in the walls and in the ceilings and all of those things. And that's what, if you walk into a basement, a lot of times what the basements are, it's just a drywall blank, basement.
Doesn't address your question?
Yeah.
Thank you. All right, at this time, we're back to entertain a motion.
simple?
You can make it simple, you can make it in any manner you want. I think the thing to do is get something out there that is a starting point where we as the panel can start deliberating amongst ourselves as to reasons of support or not support for the motion, and through that discussion be able to extract some points that become a sound basis for our deliberation.
Well, I guess I would like to motion that, I mean, I think it's clear that we can't motion or shouldn't motion to the fact that they refund fees. But I think we should have a motion to evaluate the policy itself and render a decision on the validity of that policy for the last 20 years that it's been in use and knowingly in use by everybody.
Well, right now, if I might, I'm looking at the appeal that's been filled out, and I'm going to just jump in here where I probably shouldn't be going, but on the appeal form, the first statement under the reasoning is requesting a determination by the building board on the case of B, finished basement valuation and fees. And then they give some background under item D at the bottom of the page that talks about policy R.01. And then it makes reference to adopted per 2310-1033. And then we have another reference to the administrative code 2310-104.13.5 on the top of the next page. So there's a lot of language in here in terms of numbers and reasoning and background, but what I'm seeing is those are probably maybe where we want to focus maybe motion and action, support or not. The other option at this point in time is I would entertain perhaps another question of legal if what I just ran through has any oversights that we probably should address, and maybe in fairness give the opponent that same opportunity to briefly respond.
I was reading along with you, but, sorry, I guess I'm not sure, quite how to answer your question.
I'm sorry, I didn't mean to put you on it.
No, I wish I could be helpful. I'm sort of struggling with, I don't quite want to put words in your mouth on how to make the motion, but it's
No, and
framing
that's
it.
unfair to suggest that you're making the motion for us, but I guess at this point I'm just trying to maybe get a better handle of what exactly the appeal is of. And at this point in time, it all seems to boil down to this valuation.
Right, I think it's, is it $50, is it 65, or is it 100 something? Essentially.
So would we be making a motion to review the policy R.01 as to the language validity of the addressing of fees?
The correctness of
The correctness of addressing fees in this policy.
addressing fees through policy.
Yeah.
And, I think before us we have prospectus of the appellant, we have the legal position, and we have Mr. Colthouse's document that gives us a little bit of background that speaks to those specific issues. So I think, was it my
rest of the policy we agree with, so
Right.
there's no issues there, it's not being brought up.
Right.
So
So,
it's
Mr.
evaluation of the, property valuation from the fees.
Right, so Mr. Thompson, if you could briefly comment on how we're just talking about this. if you
I
have
believe
any-
the policy is valid and it was set, and it was based upon Anchorage's numbers, not 1.5.
No, I'm just saying your comments relative to your appeal. It's on the policy and the fee basis?
Well, the legal says we can't ask for the refund, so I'm not gonna, so basically the policy is in place. I think the building
You're the one
official
who wrote
needs,
this, so what are you appealing? Are you appealing the
that the building
policy?
official needs to adhere to policy R 0.1.
Okay, so that's I think what this is
That's the
for.
decision
The
that-
appellant is saying that the municipality is not following policy,
Correct.
and so we're left to walk through this minefield about the policy.
Yes, well, that's gonna be fun. So we want to make a motion to hear
We're either supporting
oh, we
Mr.
have to go,
Thompson,
we either want to support Mr. Thompson, because
Or
we have to
we're
do it in
not.
the positive.
we're either supporting or not supporting. I would suggest keeping it in a positive vein, just from a historical perspective.
Yeah.
You can make a motion that's in the negative, but those usually get a little more
It's very
mired down.
confusing when you vote, yeah.
But certainly, once the motion is made, we all need to start amongst ourselves discussing our comfort level with that, reasoning for supporting or not supporting, amending it if necessary, and then the final vote, which is either a yes or no. But
Want to take a stab at it, Royal?
it's usually not the position of the chair to make a motion, but if you want, I can go ahead and throw something out, we can get this maybe rolling.
Yeah.
Okay. I move to support the appellant's interpretation of policy R01 that was been in place and part of 2310-103.3.
I second that.
So at this point, if we want to open it up for discussion.
So I guess I'll start out with that. First of all, there's no doubt in my mind that this policy was created at a time and continued for some time in a good faith effort by the administration to address concerns by the local builders. And I know, having been on the building board and spent a lot of time now in meetings and stuff, that they have a big voice and they're awful squeaky and demanding. Can't say I necessarily agree with them all the time, but I also believe that that's part of the building officials' position to serve the public, and particularly a large group such as that. And I think that's all that they were doing, is trying to to develop some understanding. And at the time, I don't know if unfinished basements existed in the code in terms of being able to charge for that, but I honestly believe that if it hadn't, and if everybody was being charged the going rate for finished and unfinished basements, what it costs to what you're being charged for the actual building itself, certainly should have been addressed. And I go back to what Ross just said. He was asked if changing that fee would be something that they would do, and the comment was, well, no, we don't do that, but anybody else can do that. But I really think it should be a partnership. I think that you guys need to work with the community when you know that there's something that isn't right. We all know that it's not right that a finished and an unfinished basement charged the same valuation as the standard building. So I think that there should be a recognition of that and a desire to assist the public in coming up with a policy or an evaluation that does work for everybody. I'm not saying that the valuations that they're asking for are correct, because I kind of don't believe that. In the unfinished basements, obviously, their evaluation was pretty darn close to what, International says now. We're right there, when you add the 1.3 factor to the $15 they were asking for, you're hitting $20, or when you add the 1.3 to the 15, you hit at the $20 that they had that established at. So, I think that shows that they're pretty close. I think the 50's kind of low, in my opinion, but I'm not a home builder. So I guess that and I also believe when you have a policy that's been there, established for 20 years, I think it's kind of a shame just to kind of trash it, and from the sense of what it was really doing, it outlined what they were being charged for, it identified it, and then established a fee. And even though there may be some, I don't even know if it's a legal problem, it says in here that the assembly is evidently the only body that can change fees or change evaluations or add evaluations or add fees. But again, I just think it was done for a purpose and a reason. It has been around for 20 years, and it's kind of like almost grandfather rights, like a house that's been built over somebody's property after so many years. You know what? There's nothing you can do about that. It's just, that's the way it is. Sure, you can take them to court and good luck, but it's their grandfather righted in, and I think this should be something that's similar, in my opinion, because it was a good thing. And I don't think it's right to go back charging the full $123 per square foot for a finished basement either. And for that reason, I would vote that this policy, I would like to say that the policy remain, but that the fees get adjusted to reflect what reality is in terms of unfinished basement.
Thank you.
Or a finished basement, excuse me. The unfinished basement is not a question or a concern right now. I think that we all agree that they're there on both sides.
I have a concern with it. I feel like, I've read this policy now a couple times, and I'm starting to feel like there is more problems with it besides just the fee part. Number one is, when you look at how this is being applied, and you look at what is actually going on out there, because when I moved to Anchorage, I bought a house, and it was a new house, and it didn't have a finished basement. It's not really a basement. It's really a first floor. They don't really put in basement. I don't really know of any house hardly that has a basement in this town. The water table's too high. So when you're talking about a basement costing less money, yeah, because they just dig the foundation a little deeper, you already got the foundation walls, that's a basement. But these houses that they're talking about, they're up on a crawl space, it's like a first floor level. There's just the way they're doing it, they say the lower level's not finished and they're calling it a basement, but I don't really think is that really a basement?
There's a definition.
It relates to grade.
It's above grade. My house had an unfinished basement, which was above grade by 1.5 feet. So I don't think that's a proper assessment of a basement. So in a way, the builders have been getting by with calling these basements when they're not even basements.
But isn't there, I think that there's a definition of basement.
The code
in the
defines
code.
The basement, Mr. Cullen, is defined, and it's gone through modifications with codes. I think it's now based on an average distance or above grade or above the lower
no
level.
more than 12 feet.
But a basement is established by code, so whether it's correctly done or not.
But I guess the way the home homeowners here in Anchorage are applying as these unfinished basement, do they fit actually as a basement?
Through the chair,
Mr. Nottinger?
the current policy that's out there right now, that we're proposing to rewrite, the waters have really been muddied. The definition of basement in that policy is not the same definition of basement that's in code. And in addition, if you read that policy, it says unfinished areas.
Right.
It doesn't say unfinished basements.
But then it also
And so
says,
it's been applied to the second floor bedroom and, yeah.
that's what I'm getting at, is if you say that you're gonna reduce this because it costs less to do a basement, that's not true, because you're applying this to areas that are not basements.
Correct.
So the policy, to me, is kind of a train wreck on that part, but then more importantly, it's a train wreck on that we've set something into a policy that's a cost per square foot in two places that is definitely gonna get stale, it's definitely gonna end up being too low over time and constantly need evaluation and need adjustment. And it just seems like this is not the place to have this in this board.
Any other discussion? Not, I'm gonna try to put out some thoughts I have. This is a tough one, and I think I'm gonna state before I start rambling through here that I'm not going to support the appeal, and I'm torn with this. I do think the building board, I shouldn't say the building board, I think the current codes recognize that policy is a vehicle that can be used by the building official. So having a policy in place is appropriate. Now, to have us render a decision on policy, I'm of the mindset that right now we're dealing with two aspects of it. There's a financial, monetary aspect to this policy, and then there's the baseline of what the policy is trying to deliver in terms of technical response or how classifications or definitions are handled. And I think I'm firmly in belief, especially since the follow-up for the last appeal we had, that it's going to weigh out that we don't have the ability to influence a monetary resolution of this. So I think the board is going the wrong direction to support an appeal that has a tie-in with financial remuneration for the appellant. And that's primarily why I'm not supporting this. I don't think by not supporting it, we've taken away the appellant's right to regain that money. There are other avenues for them to pursue that within the municipality. Now, relative to the policy itself, I think it's one of these documents that it has a lot of time and a lot of effort involved. But I don't think it has the effort that's needed to reflect where we are right now. I mean, it's taken a document that started 20 years ago, it's done some modifications to it. Now, one could argue, well, that proves that it's a perfect document. I tend to think not. I think that there's a lot of things in that policy that can become codified and resolve this issue. In other words, the definition of unfinished finish, if you want those, put them in the code as what a definition is. And then they become defined. And that's what we, as a municipality, accept. And it goes through a process of deliberation by the committees, action by the board, and ultimately the Assembly's action to codify that. So I think there are policies that are appropriate for an interpretation point of view, and that there are aspects of this policy that are appropriate maybe to become code. If they don't change and continue to be policy, I suggest that there be a modification to the policy. So I'm not supporting the motion just because of the tie it has financially. And I think that I've heard enough spoken tonight that the municipality is moving forward with understanding that there's a mayoral appeal. I don't think the homeowners are going to go away, home builders are going to go away on this issue, and they're going to have a voice and they're going to be heard. And I think that we have the building department willing to sit down and work through this and come up with a policy that's in place. So I think we should act on an up or down on this, and then I think what we can do is follow up with some recommendations that we can make to the building department and to the assembly on the policy and some points or aspects. But myself, I won't be supporting the appeal again because of the issue being tied to fee, which we don't have authority to decide.
I'm supporting it because we aren't deciding, what I heard that we don't have the authority to decide or to state is to, state that the municipality of Anchorage has to, reimburse people the fees. I guess I still think that the policy was good and was done in good intent, and it sets an amount of money, even though I may not agree with the amount of money, and we can take care of that in recommendations. But I think that the motion was set forth to go to it, the valuation and the valuation of finished basement. It says valuations and fees, but I believe that the motion was to,
Do you want to have the motion with that?
yes, please.
Motion was made to support the appellant's appeal of R.01 that has been in place as well as 2310.
I think I made an opening statement, the appeal of the finished basement and valuation and fees, and then made the reference to policy. And I'm just taking what has been
Right.
on the appellant's.
Right. So, I'm going to vote in favor of that. I'm going to support that because we aren't stipulating that they have to do any reimbursements, but I think that this policy has its place, and it sounds like they're going to do a similar policy. So, I'm going to stay in favor of it.
Any other deliberation, discussions?
Does this have to be unanimous?
I think probably just 2 votes to carry, but, it may be one of those things that it goes back to the, goes back to the larger board if necessary.
Yeah.
Independent, but
Which we probably will. I agree with you. I don't feel like we have a path on the financial part, but I do feel like we have the authority to look at this and rule about what it's saying. And because what I'm getting out of this is that the code officials have the right to interpret code. The previous administrations interpret this one way. It looks like to me they're interpreting it maybe now that this value needs to be multiplied by the 1.3. I don't think that's modifying, they didn't modify the number. It's their interpretation that this value needed to have the Alaska factor in it. So I feel like that would be within their purview to do. The numbers are not out of range for what, even with the 1.3, so it doesn't seem like it's it doesn't seem terribly unfair or unjust. So I don't have an issue with it, the way it stands and what their interpretation is. So I would be voting against the motion.
further discussion? I'm torn on this. It's one of these cases where I almost envision or dream that there would be one more week and that these two bodies would have gotten together and been able to kind of discuss the perspective that we dare tonight, because it does sound like this is moving toward a resolution that is obtaining or meeting, Mr. Thompson, your goal of
I got a letter that said no and that they wouldn't meet with me, so if
Well-
you're saying that and you two say no, then no, it's not heading that direction.
Well, I'm just saying that through the discussions or the aspects we've had, it's one, been recognized that the policy needs to go through modifications based on 30-day notice and the steps, and I would,
But that's not what we're here for. We're here, what's in place today? Not what's in place tomorrow.
so if I were to read the first sentence, and maybe this is going to sway my decision. Policy R01 states, for the purpose of this policy, the following definitions, requirements, and construction valuation apply. And this is based on policy R01, which was formerly, I think, 42 in the previous 19 years or whatever. And it does at the bottom state all finished basement areas will have a construction valuation calculated at $50 per square foot. So, again, I think this is going to boil down to a policy. Is it a document that is appropriate or recognized as being binding? We have tables that have these valuations, but we also have policy, and I think it goes back to Mr. Kohlhaas. I'm looking for your summary of points. And I think it was 2310-103, 3.1, general. The building official is authorized and directed to enforce the provisions of this code, to render interpretations of this code, and to adopt policies and procedures in order to clarify the application of its provisions. So this is specifically saying that policies are within the building official's purview. And counter to that is going back and looking at dollar values. It doesn't seem to support that dollar values or the determination of monetary is within that purview. That's the point I'm struggling with. The value we have in policy has never been codified, and what I'm understanding is to be codified, it has to go through the assembly procedure. So I think that, in my mind, puts a split between the valuation and policy. So I guess what I'm hearing is just about everything in the policy would be fine until you got to the dollar value, because that's never been codified. So that's my reason why I can't support the appeal, because it is ultimately getting to that dollar valuation. And I think, you know, I know this is the building official has a terrible job relative to the pressures that they constantly receive and perspectives. And I know when I come out to speak on certain issues, we're trying to make things happen that maybe we've gone too far in terms of an interpretation, or we're actually in some hot water and looking for some resolution. But what I have found, it has been a group that's been good to work with in all the years I've practiced up here. But I think that the problem I'm having is the way the $50 was established was never legally done. So I can't support the motion.
Can I ask one question?
Mr. Thompson?
So
It's kind of abnormal
I'm just asking,
questions
the
at this
next
point.
time you go in, and you have a discrepancy and there's a policy, and they just want to eliminate that policy and not let you do it because the policy was there, that's fine?
Didn't say that.
That's what you're saying, but.
No, what I'm saying is the $500.
That's what you're saying.
What I'm saying is the $500 is erroneous. No,
For the $50.
What you're saying is the policy is not valid.
well, if you want to argue with me, I suggest we take it up after this meeting, but my feeling is I can't support your appeal based on the facts that you have a right as a building official to create policy, but you don't have the right to establish monetary value without it being going through the process of the municipality of Anchorage adopting it. And I know in my years when you were the building official, we never saw the administrative code. You dealt with it and went forward. A lot of these dollar values are all dealt with that. They ultimately get approved. So that section in the administrative code that puts numbers to things has been approved. I'm suggesting that this has not gone through speaking as panel member in terms of amongst the panel group about how my vote's influenced and which way I vote.
And I think we could go back and forth about this all night.
Yep.
And that's not what we're here for. I think that we've made our decisions and, I guess that, I'll say that I'd like to think that at this point that, the MYA, short of just suggesting that they establish the fee for finished basements at that $122.
Can I point out one more thing out of policy, that policy AG 35, signed by Ross, assigns a fee to on-site septic and tank installation permit by amending it as per policy.
So maybe that's something that will be taken up as they look at this policy. I'm just making the
Just
point.
pointing out that you
I'm
can't,
just
on one
making the
hand, say
point
one
here
thing and say
that
another.
because it was done for the past, it does have a precedence. It doesn't necessarily have a legal precedence. And I'm just saying that it would maybe be advisable, and we can take this up after our action on this, that maybe policies that do contain monetary value are reevaluated and taken to the level of assembly approval. So I'm just, it's been pointed out to me that the number aspect is not your purview.
So I guess I would still like to, and I don't know how this fits into it, but again, I'm hoping, because I do think the valuation for a finished basement in the amount that's stated for the regular building is too much. And I guess it takes action by the assembly, some sort of amendment to that. But I'd like to suggest that you guys work with the building, with the home builders and work out a fee that is reasonable and get that quickly put into effect. Leave this $50 into effect for right now with the 1.3 amount to it, because I think that that's fair. I mean, I do. I mean, I see the $50 even going up a little bit myself, but I think if anything, it's, they may have underpaid for a lot of years. So,
Second that.
but I still think that going the other direction is not right either. And again, I do think that it's part of your responsibility to, when we see things like this, to assist the appropriate public people and help them get through this process. So,
For our recommendations, would that be something we do after the fact, is that we do through email back and forth between us and develop that, or?
I think in the past on actions I've seen the board take, it can be a follow-up recommendations, it can be advisory form, an advisory form to the building department. If we wanted to take it to a level of informing the assembly, I guess we could ask that that be passed on to the assembly through the building department, but I think it's fair to deal with those. I guess, don't think that we necessarily are gonna go home tonight if we try to intertie all those recommendations
I don't
within
think so
an
either.
action.
Could I suggest that in my mind, and I'd like to hear your guys' thoughts back on this, because obviously now I'm gonna tilt this thing. And I'm totally open to going either way, but argue back or against me, what I'm thinking is that they, to me, have the ability to interpret this policy that's written on what that policy means right now. They're the building official, and they're interpreting it. Is it a stretch that they're interpreting it to mean that valuation put there needs to be multiplied by 1.3, the way the policy's written? So in my mind, I'm saying the policy is, the way it's written, was in effect, it was applied the way they're interpreting it at the 1.3, and to me, all that fits perfectly in place. I don't really feel like it's the right way to do it, but this is what's been going on for these years. Now, in previous administrations, it was, they used 1.3 for some numbers and not for others. That's the way they interpreted it. So I have no issue with saying that now they're interpreting it this way. It doesn't make the policy void. It doesn't mean there's any laws were broken, and no one was treated unfairly to me because the numbers still came out, I believe, at the right rate or lower. So that's why I would vote against the appeal, is for those reasons alone. I believe it's in effect being reviewed and interpreted correctly.
Except last summer, they paid me, they didn't charge.
I think you're very lucky, and you shouldn't complain.
And
That's just
I
what the
think,
policy was.
I think, as we discussed this, those kind of points, I think are valid, and it, in my mind, reinforces that again, it's an interpretation and the policy does not get into the factor.
Did I get you, Roy?
The same way that we're not sitting here looking at how Mr. Wade and the original committee established the $50.
Right.
I mean, it's just been there and it sits there, and so, the way Mr. Cowling summarized it eloquently is nothing's being done out of order relative to an interpretation of policy. Now, there may be a challenge that one hears as one tries to recover money based on that, but that's another day, and that's maybe another day with us or another day in court.
It's outside our purview of this situation.
Any further discussions or deliberations?
You asked me right before if I agreed to what was going to be interpreted, and I answered whether or not policy R01 is valid or not. Right? That's what you asked me, and I agreed to. But what we've talked about is not that now.
Well, Mr. Thompson, I think we're going to reach a point where you may walk out of the room real happy or unhappy. And you can see right now with 3 people that you're hearing perspectives that are tilting it this way, and a third vote is going to say yay or nay. And you have other recourse on this. I'm just saying, this relative to this policy, the point that's been brought up, and again, we'll speak to members of the panel here where it's appropriate, is the policy is an interpretation. I don't suggest that Mr. Wade interpret it necessarily the same way that Mr. Thompson did, or other building board officials. But right now, Mr. Thompson isn't building official. He's bringing up some points that we need to consider and the city needs to consider. The bottom line is, there's an evaluation chart, and then there's the policy, and the policy describes what is finished and what is unfinished. It establishes $50 as a value for an unfinished basement, and right now the forms are saying that there's a 1.3 factor applied to these costs that are established. And so probably where this thing got off course is when Hanson came about, was not going back and looking at this and saying, oh, wait a minute, is this policy correct? Should it have added language that this is $50 flat, or is it 50 times 1.3? That failed to happen. But I don't think anyone has done this maliciously.
No.
And I think this is right now just the point that it's going to see some adjustment, and it's appropriate with the current building board that this occurs. And they're politically savvy enough that there's a building board community out there and assembly members that will be interested in seeing this. So I again think that I can't support the bill.
I motion we vote.
Okay.
A second.
Now, since the motion was formed in the positive, a yes vote supports the appeal and a no vote denies the appeal. So all in favor of supporting the appeal, please signify.
Yes.
Mr. Field. Opposed? Aye.
Aye.
Mr. Callen and Mr. Steele. So I think at this point, Mr. Thompson, moving forward with this, I think both the members of the panel and I think you as the appellant have the right, and I think the municipality does as well, to request this have the de novo, which is the broader presentation to the full building board, which is another avenue. And then other action beyond that is, I think the recourses are understood. But I want to thank everyone for dealing with this evening. Is there any follow-up that we discussions and forward something to the city relative to
I think
this
we either
issue?
got, we, just in my mind, I feel like this policy, I haven't read what you guys wrote, but boy, I hope you really cleaned it up. I guess, I don't know if it'd be appropriate for us to actually read that and comment, even though we ruled on this, but it obviously needs some work. I think the numbers need to come out, and I think that we should refrain from any policies that's setting fees for items. I think they should be done in such a way that they stay with, like the IBC table, maybe unfinished areas are defined as unfinished and not a basement. It's just unfinished and they're at 50% of the stated fee or something, so that it gets adjusted over time and there's no argument, doesn't have to be reevaluated and rehashed out with the community.
Yeah, I think that's, you know, I guess that's where I have a little bit of a problem, because that's like taking the long train, you know what I'm saying? I mean, you know, sometimes they're putting in policy to make things happen and happen now, to react to pressures that they're getting from the public, and that's why they create a policy that identifies some fees. And, I mean, Ron pointed out one other, and I don't know if there's others that identify fees or not, but there's a reason for doing that, you know?
Oh, I'm sure there is.
You know, so,
I can see why they
but
get to it.
but if you have to try to go through the assembly every time you want to change a fee, I mean, they aren't exactly fans of the building department anyway, so.
Well, that's why I'd like to see it attached to something that's increased over time, that gets it to where we don't have to keep fighting it out. And that way it'd be indexed to the cost increases automatically and wouldn't be arbitrary, and then we wouldn't have this fight every so many years when there were $15, that's so low, or $20, that's so low. It obviously hasn't been reevaluated in a long time.
Yeah,
So that's-
well, and I don't know if it's as much about the fee as it is about, what I want to say. Well, it is about the fee because there is no fee established for finished basements, and there appears to be a need for that.
Through the chair.
I think we're off the
There is
record
one.
now.
Well,
There is
we
one
gotta close-
established.
So,
Excuse me, we have acted on the case. So at this point, the panel is in a discussion on this issue, and I think it's fair to invite comment from both sides here.
I was going to say, I've passed my copy of Title 23 down to Sam, that there are provisions in the Title 23 section that establishes the building board, that there's a provision for the board itself to bring forward proposed amendments to code. Not that we want to pass that duty off on you, but there is that provision. And I would further say that I learned something the last time I was in front of the board, and I've learned something this time. And my goal would be for the next couple weeks, until they find a permanent building official, might be longer than that, is to work to correct these situations that we find. Now, the opinion on correcting this one, clearly there's different sides of the table. But now that we have a decision, I agree that it makes sense for us to move forward and correct how the policy is written, which we've taken the first step at. I think that I'm not going to say with concrete certainty we'll do this, but I could see an approach like Mr. Calley described, which is perhaps the finished basement valuation is tied to a percentage of construction valuation by code in, using the building valuation data chart as a basis. That's an example. I don't know if that's the right example. I don't know if that's what the administration would bring forward, but I can see that there's room for improvement.
If I might, it just seems to me that, as a building board member, we've been asked to review codes on a cycle. We've come up with amendments that we feel are appropriate. Some carry the day, some don't when they get to the ultimate decision maker being the assembly. One thing that would be, I think, positive relative to a board perspective on this is for this issue to come to the board as this is a proposed change to the policy language, and have a public hearing at one of our regular meetings for the opportunity of the public input in that. I'm not naive if that didn't happen. We're going to see that in the sidelines occurring with members of the home builders and directly with the assembly members on the issue. The assembly could just that I like the procedure on these kind of things. If we're really to be advisory and assist, it'd be nice to get that opportunity to see these changes and discuss them at the board level, because we do have members that are home builders, and I think there would be some good dialogue and perspective offered there as these become modified.
I was gonna ask that builder, I thought it's supposed to have people that are affected in that area on the 3-member panel. Why was there no?
We established, and a lot of it's on availability, so it might have been, you wouldn't have had this for another 2 months, I don't know.
It was very tough. I had the 2 other gentlemen that I
But
had
it's like
requested.
it would make more sense to people who've been dealing with it for 20 years than people who have never dealt with the issue at all. But the bottom line is, you basically just said policy can just be wiped out at any time and you don't have to adhere to it.
Didn't say it was wiped out, it's still open to interpretation, just as any aspect of the code is wrong. And
Well,
I would
it's pretty,
suggest, I would
it's pretty
suggest,
clear in the policy.
I would suggest over time, the buildings officials have not carried necessarily the same interpretation.
Absolutely, they did.
Well, and I think that the building official at this time has the right and the ability to change or modify those policies, right? I mean,
They also have the ability to not want to pay unused inspections. It's like you see a pattern. You need to, they ended up giving me the refund because it was found out that they owed those unused inspections. And what I'm getting at is the original thing, I had to take it to the building board to get them to discuss it. I still think they should sit down on this because there's one way of doing business. And whether or not what's in the policy is legal or not, the policy's still standard at the time. The building official might have been not legal to write that policy, but that was the policy of the municipality.
The policy
That was
does
an
not
agent
state
of the
anything
municipality.
about factors, Ron, and I think the basis of our discussion is it had nothing to do with the percentage increase, which I think you focused on. I think the valuation of $50 or 15 has been
So
held,
you set the fee and I'll ask it for.
Has been held true.
That's a good idea.
has been held true. And your comment about the appeal, we got more money on the recent, that came in front of the panel, and the panel,
No, you guys didn't do it.
it came in front of the panel, and out of that outcome, you have the
You guys,
conversation.
no, you threw it out of that panel. And we had to go. a different
Again,
route.
I don't want to be in a position of being argumentative. I apologize for that, but I don't think it's appropriate to continue in this style. Any other board comments?
Nope.
So I'll take that as no board member comments.
No board member comments.
Can I get a motion for adjournment?
I'll make a motion to adjourn. I second.
I got a motion to adjourn in a second. All in favor, hearing none, we stand adjourned. Thank you.